has an equal amount of time, which is 20 minutes per side. The appellant will go first. The appellant can reserve up to 5 minutes for rebuttal after the appellee has spoken. That's basically all you need to know. Everyone here has done this before. If I haven't explained anything that you have a question, I'll ask when you start. Otherwise, we'll call the first case, which is TR Investor versus Manatee County. Ready?
Good morning, and may it please the court. My name is Ryan Reese. I'm with the law firm of Moore Bowman & Reese, and I represent the appellants. And your honors, I'd like to reserve 5 minutes for rebuttal.
5 minutes, you got it.
By way of a very brief background, this case challenges the constitutionality of a land dedication imposed by the county as a condition of development approval.
Before you say something else, you said it challenges the constitutionality. I thought that issue was waived by your side.
It challenges the constitutionality as applied.
Okay.
I'm not sure what waiver the court's referring to.
Well, we'll get to that, but
sure.
Proceed.
Okay. So the appellants in this case are 3 real estate developers in Manatee County. Each is developing residential subdivisions on their land. As part of the permitting for those projects, they have to proceed to the county site plan and plat approval process. Because each of the developers' lands contains isolated wetlands, each is was required by the county to dedicate a 30-foot strip of uplands adjacent to those wetlands to serve as a wetland buffer. And that's purportedly to protect the wetlands from secondary impacts.
So your complaint is that they never did an individualized analysis of an impact study as to why they need 30 feet. They just followed the minimum that they're entitled to grab, so to speak.
That's correct. That's the merits determination that we challenge under the Dolan proportionality problem.
Well, let me ask this question, because let's just get to the heart of it. So I've learned in 10 years, 20 minutes is very long. So we've all read it. We appreciate your issue. We really do. But it appears that the case law is against you. But I appreciate your argument in terms of the Army Corps, DEP, local water management districts gave you less than the 30 feet. But yet, the Florida Constitution, the legislature mandates that local governments preserve and conserve wetlands. So this appears to be legislated. Now, we don't know, it's not on the record. It's not going to be based on our decisions, not going to be based on that. But you have to assume the county did a scientific study, a painful, process of citizen complaints and all that kind of stuff, and came up with a uniform buffer. It's 30 feet for everybody, not just TR. It's 30 feet for everybody. So tell me why this isn't legislated. And because I read your brief and I see it appears you don't contest the regulation, the public policy of the regulation, the enactment of the regulation. You don't contest that wetlands should be preserved and conserved. So with that in mind, your client bought the property with this legislative edict in mind that's uniform to everybody. Why should you be compensated? How is this an unjust case?
So, Your Honor, that's a complicated question. It's got a couple of parts to it. First, we never raised the legislative versus adjudicated exaction issue in the briefing because the county never raised it.
So the trial court did.
The trial court cited to this court's Highland in the Woods opinion, where this court determined that in that case it wasn't comfortable saying that the condition imposed in that case was fully legislative.
Because the legislature didn't say, hey, you got every county, every local government has to do reclaim water. That's what Polk County decided to do. So that's why we couldn't decide. Here, the Florida Constitution and the legislature says wetlands. I get it because of the development of forests. I understand your client's concern of waste. We just can't develop anymore and enjoy and realize the economic value of our property. But do you see where we are?
I do, Your Honor, and I think I can answer maybe better this time around. this condition, and I understand that the policy may be legislative, but the condition was imposed as part of a site-specific development process. It was imposed by county staff at the site-specific level. It's no different in that sense than the exaction imposed in Nolan, no different in the sense than the exaction imposed in Kuntz or Dolan.
Yeah, but if it was my property and I wanted to build a residence, and a big residence, I would still have that 30-foot setback in that area. I couldn't develop it, right?
If you were adjacent to
So you
ISO.
big huge house, I get it, can't afford it, but what I'm saying is it applies to everybody.
And certainly, you know, I think perhaps Your Honor's concern may be more of a due process concern. You know, could we have challenged facially based on the enactment?
Well, that's what the US Supreme Court says, it becomes legislative, it's a due process issue, not a constitutional taking, Fifth Amendment.
And I would respectfully contend, Your Honor, that this isn't legislative, it is adjudicated because it was applied as part of the development approval process. It may be a legislative policy that's out there, but staff still has to apply it. In fact, the county, here's a great example for Your Honor. The county had a provision in place, I think up until 2017, 2018, which was called a plan variance provision. It was like paragraphs C24 under the comprehensive plan, where an applicant could go in and seek a variance from legislative policies in the comprehensive plan. And that provision was abolished by the county a couple of years ago.
Did the legislative process abolish that? And then the second question is, does the staff now have any discretion whatsoever to do that for anybody? To decrease to 30 foot, it doesn't seem like we do.
The county has no discretion whatsoever. It's in their comprehensive plan. As this court's well aware, the Growth Management Act, Chapter 163, Florida statutes requires compliance with the comprehensive plan. So they had absolutely no discretion whatsoever in this case.
So if they have no discretion, what was the purpose of offering a 5-foot buffer?
To demonstrate that the Department of Environmental Protection and Southwest Florida Water Management Districts are the state agencies who are responsible for the protection of water resource management. And if they're going to say, in this case, that these appellants developments were permissible with a 5-foot planted setback or a 5-foot planted wetland buffer or a 0 buffer with the installation of protective fencing, that just demonstrates the county's policies. It's just a fixed arbitrary number. It's not adequately tailored to the impacts of the applicant's proposed developments.
So you filed a deck action and your issue is unconstitutional as applied because then you had filed all your paperwork to get your approvals and they disapproved it without 30 feet.
Staff would not support approval of the request without the 30-foot buffer.
You just said they had no discretion.
That's correct. The applicants in this case were unequivocally required to delineate a 30-foot wetland buffer tract on their site plan, and then later as part of the final planning approval process to dedicate all the wetlands and all the wetland buffer area as part of the common area calculation that ultimately gets turned over to the homeowners association. And so I want to step back just a minute because I think this case differs a little bit in this court's 2017 Highlands in the Woods, Mandarin, and the 2020 Murphy Auto Group decision in the sense that we're at the very, very threshold question here. Is this an unconstitutional exaction? And the court found it wasn't. And I want to, I think, stress, because I think it gets a little muddied in the briefing, what exactly the test for an unconstitutional exaction is, or an exaction in general. And that's one simple question. Could the government have obtained directly what it otherwise sought to obtain indirectly as part of the land use approval process? And that is the threshold issues stated up front by the United States Supreme Court in Nolan, in Dolan, and in Kuntz.
Okay, so let's say TR builds. And you don't need a permit, but you build, and then you get real close to the wetlands. Could the county come in and say, stop? You need to stop, mid-law.
In this case, they wouldn't have been allowed to build. There was no discretion whatsoever to build anything.
So what I'm saying is, you're saying it's an exaction, but it's like you started building. And you got so close that you're almost interfering with the wetlands. Can the county stop? Based on the law. So what's the difference? In requiring it in a permit,
Because you have to have.
you're just doing it on the front end.
You have to have site and planning approval approvals by the county to move any dirt out there. I mean,
It sounds to me like you're challenging the county's determination of 30 feet, which happened a long time ago.
in a facial challenge, challenging that 30 feet would be more in the way of due process. And in terms of arbitrary.
This is a 30 feet that you still own. See, there's a burden with wetlands. Either the county bears the burden or the owner bears the burden. So you bear the burden initially, but then when you sell your lots for less than you believe they were worth because of the setback, then the public at large, aggregate, bears the burden. Somebody's got to bear the burden.
Sure.
Of maintaining the wetlands. So the county's saying, we're not going to do it anymore. If you don't do it, we can come on the property with notice.
So to your Honor's point, this would be wholly constitutionally permissible if the county had just couched this as your Honor said, just a wetland setback. You appellants cannot build any vertical improvements within 70 feet of a wetland. Okay, that would be entirely permissible. It wouldn't be an exaction because there would be no conveyance of the property interest. But I want to correct one thing.
But the conveyance is to the owner. It's not to the county.
It matters not. It's the fact
It
that
does matter because the whole thing about the Fifth Amendment is you're taking my property and giving it to the public and you're not paying me for it. They're giving it back to you. They never even took it actually. And then you give it to the ownership, the homeowners, members.
I would respectfully submit, Your Honor, that it is absolutely an appropriation. And I think that's where the trial court got hung up on this case. They focused on the end user. Well, the county, we didn't take anything here. We didn't appropriate this from you. You gave this to the homeowners association, but it wasn't voluntary. The county and the trial court's conclusions ignored the fact that but for these dedication requirements, these buffering requirements, TR Investor would have had 4.90 acres of property that it still owned, that it could have created additional lots potentially, created larger lot sizes, or added amenities in the
So
subdivision.
you're saying you could have built on wetlands when the law says you can't.
These aren't wetlands, Your Honor. The wetland buffer is entirely.
That's the problem, is you didn't make that argument in your brief. You don't tell us this is not wetlands. You imply that by saying it's something else, but you really don't challenge that. Tell me where it is, please, because I was looking. Because you didn't argue in front of Judge Sniffen. Because Judge Sniffen didn't say anything about making a judicial determination whether it was wetlands or not, because it wasn't before it.
Your Honor, I will find the point in the briefing where we said that it is entirely uplands. I mean, we made a point in that complaint. I'm 100% certain that it's an allegation in the complaint that the wetland buffer is over entirely upland developable property. And that's why we're so confused by this requirement, because not only, so nobody disputes that there's protected wetlands on the property, but this is a buffer from the wetlands. Well, wouldn't a rear yard setback serve the same purpose? But here, there's the wetland, then there's a 30-foot wetland buffer, then there's your rear yard setbacks. Let's call them 50 feet. I don't know what the number is offhand. So it's really, the rear yard setback serves as a buffer from a wetland. So it makes absolutely no sense. But I'm 100% certain that we set forth that this was a buffer over entirely upland property that was otherwise developable. And that's why the argument's so, that's why the detriment is so severe to the owner, because they could have used this land at a very minimum for larger lot sizes. This land is otherwise developable, but for the county's 706.7 provision that says you can't use the wetland buffer. So they have, in essence, and that's why we call it the de facto conservation easement, they have in essence precluded you from using this additional 30 feet of land when you're already precluded from using the wetlands, rightfully so, and you're already precluded from using your rear yard due to setbacks. So, so again, I would stress to this court that the relevant inquiry here and the question that this court should be asking based on the trial court's determination is, could the county have required this buffer dedication independent of the fact that the appellants in this case needed something from the county? Here, land use approvals. And the answer to that question is an unequivocal no. And it's that coercive demand, and the word coercion is used by Justice Alito throughout the Coombs opinion. It's that coercive demand alone that triggers exaction scrutiny. It's not who the end user of the property is. The county, and I quite frankly think that that's really what hung the trial court up here, was the fact that the county, well, we didn't take any property. Yes, but you required an appropriation. You required you required TR Investor at least to take 4.90 acres of property, set it aside so it's included in a common area calculation that ultimately gets turned over to the homeowners. And takings jurisprudence, I would submit, is clear that the ultimate recipient of a government appropriation is immaterial. What matters is the county's act. And that's in requiring the owner to suffer here and a full divestment of their title. I mean, the TR Investor lost title to this property. And I think
you lost title to the property anyway. You would have conveyed it to the homeowner anyway.
So that is a distinction, Your Honor, that I think the trial court and the county cross over because it's factually incorrect.
Before you finish that, I just want to let you know you have 5 minutes. You want to save it for rebuttal, or you want to keep going?
If I may answer Judge Lee's question, and then I'll reserve the remaining. Factually incorrect that this 4.90 acres that TR Investor dedicated to the Homeowners Association would have otherwise been considered in the common area calculation. That property would have remained with TR Investor through the planning stage, which it could have used for larger lot sizes, potentially more lots. That becomes a valuation question potentially later on, and or additional amenities. The fact that the county required it as buffer was what triggered its inclusion in the common area calculation under 336.4 to be then turned over at a later at the planning stage. And with that, I'll reserve whatever time.
I'm just going to save you 5 minutes.
Thank you, Your Honor.
May it please the court. Assistant County Attorney Chris DiCarlo, together with my co-counsel Whitney Hodges and William Clegg, on behalf of the appellate in Manatee County in this case. Your Honors, I want to start out by, I think, the necessity of clarifying something that was discussed by appellant's counsel in this case. As it relates to count one, let's be very clear, there was no dedication of any right, title, interest in property or money that was given to Manatee County with
Well,
regards
it's
to.
going to go to the homeowner.
Beg your pardon?
It'll ultimately go to the homeowners association, correct?
That's correct, Judge. I do want to draw the distinction for the
So
court.
isn't, I mean, how can you argue they're not taking property if they say give it to the homeowners?
Well,
The homeowners associate they're still losing property.
there's two issues, Judge. I want to clarify something. I think there's a little bit of a commingling going on here with regard to count one and count two. So in count one of their complaint, they simply alleged that the requirement for the wetland buffer regulation in and of itself constitutes an exaction without any reference to the dedication requirement that they raised in count two. Because remember,
Before you, I don't want to, I really apologize, but I want to make sure I'm following your argument.
sure.
Are they saying it's an exaction in and of itself, or are they saying it's an exaction without an individual analysis of impact studies?
Your Honor, they're saying it's an exaction because there was no individualized determination that they.
Okay, so they're saying more than it's an exaction.
Yes, Judge.
And do you agree the county didn't do the individual impact study?
Your Honor, there is no requirement for an individualized determination.
Okay, but I mean, to
occur.
answer his argument, that's why he's making the argument. He thinks there should be a requirement, and that.
An approval on a property owner giving something of value to the government for a public use. That something is either title to land, an interest in land like an easement, or money. That's what's absent from this requirement here. This is a requirement, this is a development restriction. It is a restriction that precludes the developer from using that portion of the property. It doesn't require them to give or dedicate anything to the county. And that's what I take issue with in the appellant's argument before the court. They're kind of glossing over that part. They're saying, well, there's a use restriction, Your Honor, and therefore that equates to an exaction. As the court knows, mere restrictions of use, Your Honor, do not in and of themselves equate to an exaction.
Well, the city of Monterey talks about Nolan Dolan doesn't apply when there's no dedication of an interest to real property, but seems to be extended to money exactions. My point is, wetland buffers are for the public good. So they are for the public good. Generally, the government has the burden of taking care of wetlands. Why isn't this, you're just shifting the responsibility to the developer, and by shifting the responsibility, you're saying two things. Don't build here and pay the money to preserve it. So why is it that's some sort of exaction? You're requiring him to do something the government should do. Because it is for public good. You have to admit that wetlands, taking care of wetlands, we should, but it benefits everybody, even though the Twin Lakes residents could exclude Mr. DeCarlo and Judge Sleep from coming on if they wanted to.
Well, Judge, again, I think the primary distinction is that they're not giving something to the county, to the government. I don't think that they can bypass that aspect of it. In all the cases where we talk about exactions and where the court has determined that an exaction occurred, think about Nolan, Dolan, and Kuntz. In those cases, the government was required to conduct the individualized determination, the rational nexus and proportionality analysis, because the court said, wait a minute, if you just took this easement, think about the case of Dolan. If you just took this requirement for the Greenland, or think about Nolan, if you took this requirement, you required this property owner to allow an easement for public access across its property, and you just did that outside the context of a development permit, that would clearly constitute a taking that you have to
That raises
take.
a question, because the code that 706(8) that was invalidated and you've amended, and specifically said that Nolan Dolan does apply when you require an easement. Is that easement for the county to be able to come on the property to maintain, or is that easement for the benefit of the public to come in on Twin Lakes?
Well, Judge, I'd like to answer the court's question, and I will, but I do want to clarify one issue for the court, and I think the court understands this, but the court needs to understand there is no application of 706(8)(b).
Oh, I know.
To any of the properties at issue.
But what I'm saying, I think that Mr. Reese is saying you're doing indirectly what the court didn't allow you to do directly, and
Well, in Mandarin, the court did rule that the requirement for the conservation easement constituted an exaction for the reason that we're talking about, because the county got an interest in that property.
yeah,
And that's-
legal interest, but
that's-
what about a possessor, a conservation?
Well, that was the conservation easement requirement in 706(8)(b). That was what the court took issue with in Mandarin. And that was what the court ultimately, the trial court said ultimately in that case constituted the exaction. That's what triggered the taking, was the requirement for the conservation easement. In Mandarin, the trial court also looked at the issue of the constitutionality of these regulations. Now, in that case, in the interest of intellectual honesty, we were dealing with 50-foot wetland buffer, but the provisions of the comprehensive plan issued on are the same as 3315 and 706.7 of the LDC. And in that case, the court upheld the constitutionality of those provisions by, after going through a trial, a 3-day trial, where the court recognized that there was a rational basis for those regulations and recognizing that it acted in exactly the manner that we are talking about here as a development restriction. And what I would respectfully suggest to the court is, I understand the appellant's argument as well, and I can appreciate the court's concerns about it, but the remedy that they had was a regulatory takings claim. If their concern in this case, Your Honor, was that this is an onerous burden, this is an overly heavy burden that precludes us from making a reasonable economic use of a portion of our property, then the remedy that they had was to file a regulatory takings claim under the Penn Central analysis. Judge Sniffen gave them ample opportunity to do that. He all but said that to them in his orders. He said this claim presents something more akin to a regulatory takings claim, which would be appropriate under the Penn Central analysis. And they said, we don't want to follow that. we're not going to amend any of our claims to assert a cause of action for regulatory taking under that standard. They effectively invited this appeal before this court because they declined the circuit court's invitation twice to amend. That's their remedy. Now, why do they not want to file a regulatory takings claim? Well, because they want to avail themselves of the standard that is applicable as it relates to its actions, and the standard that is applicable to a per se takings claim, which invites a higher level of scrutiny by the court. They don't want to get into the analysis under a Penn Central takings claim, where the court gets to look at, have you been able to make reasonable economic use of your property based upon your reasonable investment-backed expectations when you purchased this property, knowing that there was a legislatively enacted provision of the comprehensive plan in the code that requires that 30-foot buffer.
So whether it's legislative or adjudicatory, do you think that matters?
Well, I think that in this particular instance, the court wrestled with this issue, I think, a little bit in Highlands in the Woods, because it is clearly a legislative provision. It's a part of the comprehensive plan and part of the code that applies countywide at its outset. Now, obviously, in this particular case, these three appellants have come in and they've submitted land development applications to the county, and that land development application triggers the requirement for an analysis. So that certainly has an as-applied component to it. So I think there's elements of both of it. I mean, the court wrestled with that issue in Highland in the Woods and said that it wasn't clear based upon takings jurisprudence whether legislatively enacted provisions are subject to challenge under the exaction body case law, because all of those cases dealt with adjudicatory decisions in the context of land use permits. So I think there's elements of both of it, Judge. I don't mean to dodge the court's question, but there's clearly a component of it that's legislative, and then once the applicant comes in with their application, there's certainly an adjudicative component to it once it's going through that application process.
Can I ask you a question?
Yes,
The
sir.
county is not claiming this as that this property is conservation easement.
No, we're not.
It's a standalone buffer zone, so his notice of filing supplemental authority is a non sequitur, so to speak, and that's where if the county wants to do that, there's conditions precede.
Judge, that's correct. I mean, from our perspective, that's really that provision of the code that the county amended, and the county did amend it in fairness in response to the manual decision. But it's wholly irrelevant to the court's.
Well, I mean, it doesn't it stand to show that the county doesn't have that with the buffer zones,
Well,
that was not an accident?
I think what it stands to show, Your Honor, is that there was a recognition as a result of the manual decision that there needed to be that analysis of the rough rational nexus and rough proportionality, but that was not applied in this case.
But if this property was uniquely sensitive to the environment, the county could come in and ask for a conservation easement on top of the buffer zone.
Yes,
But they
sir.
didn't do that.
That's correct.
So you're thinking, don't look a gift horse in the mouth, because they say it's not wetlands to begin with. Not that we're here to determine that, but they're not really worried about that.
Well, Judge, there are wetlands on the property and there's wetland buffer associated with.
Two different issues.
Two different issues.
Right.
And they're required to go ahead and delineate those wetlands as part of their application process. The other thing I would note for the court is there are provisions in the county's comprehensive plan and the county's land development code that specifically allow a developer to come in and apply to impact wetlands. Where is that? It's in section 3313 of the comprehensive plan, and it's in section 706.7, I think it's subsections 4, 5, and 6 of the land development code. And it says that they can come in and they can apply to impact those wetlands. Now, they can't just come in and say, well, we want to impact them. They have to go through a wetland impact analysis and they have to provide mitigation criteria. But this notion that there was absolutely no ability for the developers to seek any relief from this, it is not accurate.
But they were given an opportunity and chose not to exercise that.
I can't speak to what those folks did in the development process.
Well, I mean, you would normally do that upfront, correct?
That's correct, Judge.
Okay.
They're taking issue with provisions in the comprehensive plan with regard to a plan variance. That provision was removed some time ago. But there are other components of the comprehensive plan and the land development code that allow for impacts to wetlands and mitigation. They didn't avail themselves of that. There's nothing in the record that the court will
I mean,
find.
that argument wasn't really made in connection with this appeal?
Well, we did raise they've taken the position that they raised in their complaint, Ron, that it would have been futile for them to, and I think they were trying to raise an issue of futility to avoid a rightness affirmative defense if we had got to the merits. So there was an allegation in their, I believe in their first amendment complaint, that they were without the ability to seek any relief from the buffers because
And
of
you disputing that?
yes, sir.
Gotcha.
And I'm pointing the court to those sections of the code in the comprehensive plan that allow for wetland impacts and mitigation.
So Judge Sniffen cited the common sense opinion, not this from Washington, Maryland, whatever, but the distinction in the common sense opinion is that the court articulated that the state or municipality had a requirement for a scientific study, a reasonableness study, and all of that, and it seemed to sway the court that the court didn't do a no, that seemed to placate the court to say, well, this is a taking, so we don't have that here. But one has to assume that your municipality, your county, did some sort of study to come up with this 30-foot buffer, this 50-foot buffer. Just didn't pull it out of the blue. That's why I'm stuck with legislating. You have no discretion to vary from that. You understand what I'm saying? My question. I don't know that common sense got Judge Sniffen where it really wanted to be, but he cites a lot of holding in the end, but yet there was right in the middle of that opinion, that scientific study requirement.
Well, I do recall, if I'm recalling correctly, Ron, I mean, I do think that common sense was a case that was dealing with a legislatively enacted provision.
Yeah, there were several entities that petitioned to challenge this.
But I would note for the court that, I mean, again, this particular provision of the comp plan and the code was challenged in a trial court setting. It was, again, in the interest of intellectual honesty, that was a facial claim, not an as-applied claim, but the provisions themselves were exactly the same. And Judge Hall, sitting in a 3-day bench trial in that case, he heard an abundance of testimony from county's experts regarding the rational basis and appropriateness for and the scientific validity of the size of the wetland buffers. And I realize I'm going outside the record, but I'm just trying to give the court a little bit of additional background. And in that particular case, the court said, I'm not going to determine that these buffers are unconstitutional. They have a rational, they are rationally related to the purpose that they serve, and there's a valid scientific basis for having them in place. And we're now dealing with they're challenging the same, I mean, they're challenging the same buffer regulations that were at issue in that particular case all over again. And what they don't have in this case that they had going for them in the manual was, as Your Honor has pointed out, the requirement of the conservation easement, which was essentially, if you think of it, just overlaid on top of the area that constituted the buffer. And in that, and in the manual, the circuit court opinion, which I think both parties have cited to the court, is part of the record, I think, in terms of the underlying case. And Judge Hall made a point of saying that the buffers simply call out and delineate the area that was subject to the conservation easement. They didn't take any right, title, or interest to property. If the problem he had was the overlaying of that conservation easement on top of the buffer area, and the lack of the county either paying the property owner for that property interest, or at the very least going through, an individualized determination and a dome test to determine whether it was a lawful exaction, because there can be lawful exactions. I just think that respectfully, the appellants they're glossing over what is a very key element in an exaction claim. That key element is the government has to take something. They have to take something for itself for public use. They have to require that from the developer as a condition of receiving a permit. That didn't occur here. And the appellants conceded that. It's in the record, we cited it in our brief. The appellants conceded that both in the written submissions to the court, Your Honor, as well as at the oral argument. So I respectfully, They're trying to analogize an exaction as saying, well, we can't use the property, we've lost reasonable economic use of it, ergo it's an exaction. No, they're skipping a step. The step they're skipping is the requirement for something to be given to the government. And I'll touch on, I'd like to just touch on count 2 briefly. You know, count 2 is, well, first of all, Your Honor, I would respectfully suggest to the court as a procedural matter that the issue that they've raised to the court with regard to count 2 of their original complaint is not before this court. They did not invoke this court's jurisdiction based upon the original order of dismissal that was entered. The court knows that that's a non-final, non-appealable order. They came back after Judge Sniffen entered that order. They amended their complaint. They filed a new per se takings claim based upon a claim of physical invasion or occupation. They abandoned that original count 2 claim. They can't resurrect it in this appeal. But as to the merits of that claim, what the court should understand is that they're really trying to shoehorn the facts of that body of case law dealing with physical invasions and occupations. The Loretto case, which is the seminal case on that issue, and the recent case in Tennessee, they're really trying to shoehorn the facts of that case to claim a per se taking by virtue of physical invasion.
Believe it or not, you have a minute left.
Judge,
I'll give you an extra minute to make it even, because I'm giving him an extra minute, so.
sure. Judge, I think the record, is clear that the facts and the law do not support the claims that these appellants have filed. While I can understand the court's concerns and I can sympathize with the appellant's position, their remedy was one in filing a regulatory takings claim under Penn Central. Judge Sniffen recognized that. They refused to do it. That's the reason why we're here before the court, and we respectfully request that the court affirm the dismissal of the prejudice. Thank you for your time.
All right, thank you, Mr. DeCarlo. Mr. Reese, you've got 5 minutes left.
Thank you, and may it please the court. So I want to start by addressing some of Judge Sleet's concerns. First, with respect to the issue of whether we alerted the trial court in our pleadings and this court in our briefing to the fact that this wetland buffer was indeed uplands and not environmentally sensitive. And I direct the court's attention to paragraph 7, 10, 36 of the amended complaint, and it's on page 2 of our initial brief. We filed, and Judge Sleet asked about the notice of supplemental authority that we filed with respect to the county's amendments to its land development code to attempt to conform the conservation easement requirement to Nolan and Dolan standards. And the reason I cited that, not because the conservation easement is still an issue in this case, it's not. I cited that because it's an implicit acknowledgement by the county that the conservation easement requirement had to be tailored to Nolan and Dolan. But they're a step ahead of themselves. What goes into the conservation easement? The wetlands and the wetland buffer area. So how could a conservation easement be adequately tailored to Nolan and Dolan if the buffer land that goes into the conservation easement doesn't have an individual determination of nexus and proportionality?
Did they overlay a conservation easement on top of the buffer?
Not in this case. That was an issue in the Mandarin case. But I just filed that to show that you can fix the conservation easement, and they did. They fixed the conservation easement after this court's decision in Mandarin. But they haven't fixed the buffer.
But he cited some provisions in the York County ordinances that would allow you to have additional administrative remedies that were not pursued.
That's right, Your Honor. And that was next on my list. We could file a wetland impact study. Why would we file a wetland impact study? The buffer's not wetlands. So you wouldn't, we're not impacting any wetlands. The buffer is uplands.
Yeah, but you would have resolved that issue and it would have come before us. Now you're saying it's not a wetland. We got no record saying it is or it isn't. We
Your
just
Honor,
have the representations in court and the pleadings.
well, the court must take the pleadings as true. This was resolved on a motion to dismiss. We
You
said
have
it's
an
uplands.
opportunity to have a court adjudicated or a municipal body or county.
We filed the hearing transcripts before the 2 motions to dismiss hearing transcripts before the lower court. I am confident that it was made clear to Judge Sniffen that this was uplands. It's in the complaint.
But could you still take advantage of this alleged administrative remedy?
No, because the buffer is required. So impacting it is not the issue. The developers don't want to impact the buffer area. They want title to the buffer area. Here they have been unequivocally divested of title to that area by virtue of this dedication. So it's not an issue of use, it's not an issue of what could we have done with this area. It's the fact that there was an appropriation of that land before the site planning process. TR Investor had 4.9 acres. After, they had 0. That's the key issue.
All right,
So what would a reversal be like? And what is your best case analysis, given the fact that the Supreme Court seems to have put some limits on what is an exaction and what applies, and Nolan seems to have some breaks on it based on the city of Monterey, limited to the dedication or interest of property or exaction of money like Coons. What'd you write as a reverse?
A reversal would reverse the lower court's adjudication on the motion to dismiss and remand in this case for a determination of the merits under Nolan and Dolan.
Division in what case?
Under Nolan and Dolan and Coons, Your Honor.
Nolan and Dolan deals with a bike path. That's a lot different.
A dedication.
But dedicating something for a bike path versus wetlands. Public crossing your yard to access beach, terrible, hated, versus wetlands. Requiring an owner to dedicate land for water consumption for public purposes versus wetlands. Coons, requiring you to pay for something that wasn't on his property versus wetlands. You got a hard road to hoe.
So I'm not sure if the court's referring to the buffer property as wetlands, but once again, it's not wetlands. It's not environmentally
But the
protected.
buffer is designed to keep you from interfering. Obviously, somebody somewhere who's a lot smarter than me in environmental study said, don't come 30 feet from a wetland. Somebody somewhere said it.
And that's all we've asked the trial court. We've asked the county to show their homework. How did the county, Manatee County, who doesn't even have primary jurisdiction to enforce water management resources in the state, how did they come up with 50 and 30 feet?
Mr. Reese, I don't want to interrupt you, but you are out of time. Did you want to finish that last thought that's replying to the judge's question?
I would, if it pleases the court.
Actually, stand on point there.
Sure. So, that's all we've asked, Your Honor, is to have Manatee County show how they came up with the basis for 30 feet. Your Honor cited a study numerous times in this argument, and we haven't seen that study. So if the county indeed has that study, they'll be able to present that if we go back and have a determinations on the merits to show how they adequately tailored the 30 feet to the impacts generated by these respective projects. Thank you.
Thanks both sides. Great argument as always. We have to take a short recess for panel change. We'll be right back. Okay.
All rise.